Muy buenas tardes a todos. Bienvenidos a esta nueva sesión del Aula Maekelt. Hoy, 4 de agosto, para nosotros aquí en el hemisferio occidental, 5 de agosto en el hemisferio oriental y en el sur, el hemisferio oriental, les damos la más cordial bienvenida a esta sesión. Hoy, la maestría en Derecho Internacional Privado de la Universidad Central de Venezuela y el Aula Maekelt en particular, tiene la inmensa satisfacción de contar con la participación de un muy distinguido profesor que nos acompaña desde Nueva Zelanda, desde Christchurch, Nueva Zelanda. Es un motivo de especial satisfacción volver a encontrarme con el profesor Christian Riffel, originalmente alemán, quien se formó allá en Alemania y después ha perseguido y continuado una muy destacada carrera como académico en varias partes del mundo y actualmente se encuentra allá en Nueva Zelanda, como les mencionaba. Yo quisiera permitirme, en primer lugar, antes de leer algo del muy importante y valioso currículum vitae del profesor Riffel, darle las gracias por haber aceptado esta invitación, por tan gentilmente haber dicho que sí al Aula Maekelt y a la maestría y hoy venir aquí a exponernos tan interesantes consideraciones del tema que nos plantea, relativo a ese fascinante mundo del arbitraje de inversión. Voy a leer una parte resumida de su currículum vitae. El profesor doctor Christian Riffel es codirector de los estudios de posgrado en Derecho y codirector de la maestría en Derecho Internacional y Política. Es editor asociado del Anuario en Derecho Internacional neozelandés. Hizo su doctorado bajo la dirección del profesor Thomas Cotier en la Universidad de Berna, en Suiza, y es autor de muy importantes trabajos. De esa cantidad de trabajos tan interesantes, yo me quiero citar en este momento algunos de ellos que tienen que ver con el tema a ser desarrollado esta tarde entre nosotros. Un trabajo publicado en el año 2022 sobre Fair and Equitable Treatment and the Right to Regulate, the European Union and the Asia Pacific Models Compared, aparecido en el European Law Journal. Otro trabajo que me parece muy interesante, también del año 2022, que lleva por título Geographical Indications y es según los artículos 22 al 24 del TRIPS. Aparece publicado en una publicación colectiva de los profesores Stoll y Helstemeyer bajo el título de Trade Related Aspects of Intellectual Property Rights Bill. Y hay otro trabajo que quiero referirme, que es probablemente el más relacionado con esto que él nos va a desarrollar ahora a continuación, que lleva por título Does Investor State Dispute Settlement Discriminate Against Nationals, del año 2020, que aparece publicado en el número 21 del German Law Journal a las páginas 197 y siguientes. También quería destacar que entre sus publicaciones también hay algunas incluidas en el anuario del Max Planck sobre el derecho de las Naciones Unidas. También se encuentra en el listado de árbitros para los tratados comerciales de la Unión Europea y asesor para los temas de derecho económico también de la Unión Europea en sus negociaciones para convenios comerciales con Nueva Zelanda. Es también el asesor regional para la Encyclopedia of Comparative Constitutional Law y es copresidente del grupo de interés en el derecho económico de la Sociedad Australiana y Neozelandesa de Derecho Internacional. Antes de haberse unido a sus labores de profesor allá en Nueva Zelanda, estudió Derecho en la Universidad de Heidelberg, en Alemania, donde también cursó estudios en materia ambiental, en Derecho francés y en Derecho angloamericano. También debo destacar que tiene un estudio de maestría y recibió el título de magíster en el Europa Institute de la Universidad del Saarland en Alemania y que su tesis de maestría recibió el premio Hans Werner Oshoff por excelencia académica. Como dije, es doctor por la Universidad de Berna. Tuve el privilegio de contar con la colaboración del profesor Riffel cuando era estudiante de Derecho y realizó sus pasantías aquí con nosotros en Caracas. Y también hizo una pasantía en la Embajada Alemana en Santiago de Chile. Por supuesto que tiene sus buenos conocimientos también de castellano. Sin embargo, hoy el profesor Riffel se va a dirigir a todos nosotros en idioma inglés. Vamos a escucharlo en idioma inglés y a continuación de su exposición vamos también a abrir el derecho de palabra para tener probablemente una amena discusión y una conversación. A aquellos que cuando quieran intervenir no se sientan cómodos para hablar en idioma inglés, no tengan problema, ayudaremos también a hacer la traducción correspondiente o incluso el profesor Riffel directamente escuchar la pregunta en castellano, la puede contestar bien en inglés o hacer sus comentarios en idioma inglés. Entonces, quisiera ahora, now I'm switching into English. Professor Riffel, this is to thank you so much for making yourself available and joining us today in this masterclass of our master program of Universidad Central de Venezuela. It is a real pleasure to have your company, and I'm sure we will enjoy very much your dissertation. So please, Professor Riffel, the floor is yours.
Muchas gracias, Eugenio, y muchas gracias por la invitación. Aquí estamos por la mañana, pueden ver la salida del sol acá. Bueno, estaba en Venezuela en 2008 y desde entonces el país, los venezolanos ocupan un lugar muy especial en mi corazón. Lamentablemente no he encontrado muchos venezolanos en Nueva Zelanda y no he hablado castellano por un rato. Parece que los venezolanos prefieren migrar a Australia y no Nueva Zelanda. Bueno, voy a dar mi conferencia en inglés. Espero que esté bien. Well, New Zealand has a very strong indigenous population, and it's very customary to start a talk in Te Reo, which is the indigenous language. So to honor the place where I am, Tēnā koutou, tēnā koutou, tēnā koutou katoa, which means in the indigenous language, bienvenidos todos. About an hour ago, I received very sad news from Germany. A good friend of mine died in a car accident. Rock, and I want to dedicate this talk to Rock, my friend. He was a professional sportsman in Germany. He was the coach of our national youth team, one of the southern states in judo. So Rock, that's for you. As Eugenio has said, so my background is no longer private international law, although I always had a passion and love for private international, which has to do with the professor that Eugenio and I had at the University of Heidelberg, Eric James. So at this moment of my career, I totally focus on international economic law, and I worked with the European Commission and advised them on the free trade negotiations with New Zealand. I work as an arbitrator, and my specific research area at the moment is TRIPS, international IP. I did not only do my PhD on international IP, but I've also been appointed as editor of the WTO commentary on TRIPS, so that's one of my new research projects. When I spoke to Eugenio before the talk, I gave him two topics, a trade topic and an investment topic. And Eugenio thought that the investment topic would be more suitable. So if you wanted to listen to a trade topic, please send all your complaints to Eugenio. But I hope you will find my talk on international investment law useful and interesting. So I thought I will pick the most difficult and at the moment foundational problem of international investment law, with which lots of governments are grappling at the moment, namely the incursions that arise from international investment law into national sovereignty, which caused a certain backlash against investment protection, not just in Venezuela, as well in New Zealand, in Europe, and even in North America. You can see that in the update of the NAFTA agreement, the new US Canada-Mexico agreement, which considerably reduced the scope of investor-state dispute settlement. So investor-state dispute settlement is that mechanism which gives individual investors the right to take legal action against the government and to challenge law changes. So that, of course, exposes a country to international litigation and comes with certain risks for the taxpayer. Should the state lose a case, those cases, the value can be about several hundred of millions of US dollars. So it can mean a huge burden for the national purse. Having said that, incursions into national sovereignty is not necessarily a bad thing. I attended a roundtable discussion in Washington, D.C., and I was very surprised to hear what the Mexican government representative had to say. She said that Mexico, looking back, actually benefited by being part of NAFTA, not just in a commercial sense, but in a law reform sense, because it put Mexico under international pressure to reform its internal administrative processes. For instance, they were under obligation arising from NAFTA to ensure due process to foreign investors, but instead of just guaranteeing due process to foreign investors, they rolled that out and guaranteed it to all Mexican citizens. So not just to investors, but also to citizens. So that Mexican government representative said that incursion into the Mexican legal order brought about very positive law changes, which in the medium and long run benefited lots of Mexicans, which had due process guarantees in Mexican administrative law. And it was triggered by Mexico acceding to the NAFTA agreement and putting itself under that international obligation. So incursions into national sovereignty, at first blush, that sounds like a negative thing, but it could also be something that governments want, and then they have an additional argument to bring about domestic law changes. Of course, that's the positive side. The negative side, because of the increased liability risks, it put particular countries under pressure. So Venezuela had its fair share of investment treaty obligation, but so had Argentina, which would be another example from Latin America. But not only Latin American countries. So countries have reacted differently to the pressures arising from the international investment regimes. So Venezuela and other Latin American countries, such as Bolivia, Ecuador, denounced bilateral investment treaties. Venezuela also withdrew from the ICSID Convention, the International Convention on the Settlement of Investment Dispute, which is the main forum used to settle investment disputes. New Zealand, the new Labour-led government in New Zealand also takes issue with that ISDS mechanism that is giving individual investors remedies against the host state government. So the New Zealand government, in its new investment treaties, restricted the scope of ISDS, of investor-state dispute settlement, but did not touch the broad investment protection standards. So the two most important investment protection standards are fair and equitable treatment. A foreign investor sues a government arguing that you government, you treated my investment in an unfair fashion. And then, of course, the expropriation standard. The EU, surprisingly, also took issue with ISDS, or the way it operated, even though it's fair to say it was a Western invention. That mechanism, so the historic background was to protect the former colonizers that still held assets in formerly colonized countries. But the EU went to the other extreme. Instead of abolishing investment tribunals, which are ad hoc, the EU institutionalized investment tribunals by establishing proper investment courts. So the EU distrusts ad hoc tribunals because of the changing composition of those ad hoc tribunals. And the EU argues that that leads to inconsistent decision making. So I'm an arbitrator under EU trade agreements, and the idea is that the EU will always send the same kind of people to settle trade and investment disputes as a standing bench in order to ensure some coherence, some consistency in the decision making. India is another example. India wants to bring back the level of substantive investment protection to the level of customary international law. So they also tackle the level of substantive investment protection. However, the Indian model treaty has not been picked up by other countries. So they signed 2 investment agreements with Kyrgyzstan and Belarus, but they were not able to negotiate investment treaties on the basis of their model treaties with stronger negotiating partners. Nigeria is another interesting example. Nigeria, very innovative, introduced investor obligations into investment treaties. So historically, investment treaties only impose obligations on host states to treat foreign investors fairly, to compensate foreign investors when expropriating their assets, and so forth. Nigeria turned the tables on investors and also introduced investor obligation, and that, of course, paves the way for successful counterclaims, so that the state can, in investment proceedings, can counterclaim against the investor claimants, for instance, for breaches of human rights within the territory of the host states. So that's just a little bit of a background story. And the lesson learned are, in order to tackle the incursions into the national sovereignty, there are 2 ways to do that, to tweak investment protection. One is procedural. You restrict the scope of ISDS, of investor-state dispute settlement, and you force foreign investors to go to the domestic courts. So they are not without remedies. When you take away ISDS, they still have the option to go to the domestic courts of the host state. And then it's a question, do foreign investors trust the domestic court system? Or we are left with state-state adjudication. A foreign investor can always lobby its government, the government of the home state of the investor, to bring a case against the host state, but that would be mediated through the government, and the government would assess the political implications of bringing a case against another state under an investment treaty. So one option is to reduce the scope of ISDS, and then we are left with 2 dispute settlement mechanisms, either before domestic courts or state adjudication. So that's one road that countries took, or we reduce the level of substantive investment protection. And that's the way that the European Union pursued in its modern investment treaties. And I think that's an interesting development and a model. And I just wanted to present that to Venezuela, to the Venezuelans here, as an alternative model. So New Zealand and Venezuela took a very drastic response to being exposed to international litigation under international investment law. So it withdrew from the investment system. That can work. So there are jurisdictions that are so attractive as an destination for foreign capital that a jurisdiction which will still attract foreign capital into the country regardless of strong investment protection. Australia is one example. Brazil is another example. I don't think Venezuela is in that position to attract foreign capital without certain guarantees. It's a fact that foreign investors distrust the Venezuelan legal order, and they want to internationalize that relationship and take it out of the Venezuelan legal order. So that's a weighing up that the Venezuelan government has to do by not giving guarantees under international law. Do we still attract enough foreign capital into our economy to develop the country in an economic sense? So that's a weighing up that every government has to do. Some destinations are attractive as such, and they can offer a lower level of investment protection and still get the inflow of foreign capital needed. For instance, New Zealand suffers from lots of natural disasters. So we are, especially in the South Island, but also the North Island, we are prone to earthquakes. And 12 years ago, the inner city was destroyed in an earthquake, and they used foreign insurance money to rebuild the country, the city, basically. So that was Münchner Rück, Allianz, and all the New Zealand insurance company had insurance with Northern Hemisphere's insurance company, and they used that foreign capital basically to rebuild the city. And I'm living now in one of the most modern city in the world, which was financed through foreign capital. New Zealand could attract that foreign capital through insurance and being a popular place for foreign investors. So that what the European Union did, and that might be an alternate model, is to reduce the level of substantive investment protection. You have to tackle two courses of action. So the most popular course of action for foreign investors is the fair and equitable treatment standard. It's a guarantee that hosted governments have to treat foreign investors fairly. The problem with that standard is in older investment treaties that it doesn't define fairness. So in the old treaties, it's left to arbitrators to define fairness. And everybody who has a younger child knows how difficult it is to explain fairness to a 5-year-old who says it's unfair when I'm not allowed to eat ice cream every day of the week for dessert. So I have that struggle a lot trying to explain to my son the concept of fairness. So international law struggles to define such a vague legal concept and make it operational. So what the European Union has done, it tried to provide certain criteria to investment tribunals, certain categories that meet that standard of fair and equitable treatment. And by defining the standard, the European Union also reduced the level of investment protection. I'm going to share my screen. I just wanted to show you what the formulation looks like that the European Union adopted. And I've picked the Canada-EU Free Trade Agreement as an example. So that's the legal text, and you can see it lists here certain causes of action. So it says fair and equitable treatment is one of those legislative examples. And they did not even not just define the standard, they also increased the threshold requirements by adding those adjectives: fundamental breach. So it's not enough in order to win the case for the foreign investor to show a case of breach of due process. The foreign investor would have to show a fundamental breach. So it's not, so a European government under European treaties can treat a foreign investor in an arbitrary manner. They can be arbitrary. They mustn't act in a manifestly arbitrary manner. They may discriminate, but they mustn't target foreign investors. So you can see that by defining the concept, that already takes away control from the investment tribunals. They will still have to define due process and fundamental, but they've taken back control by fleshing out, by concretizing the legal standard, and they have increased the threshold requirements. So they made it more difficult for the foreign investor to make a case. So that's one example, and those of you who have already busied themselves with international investment law, they will notice that the most important component of the fair and equitable treatment standard, according to case law, is missing. I will share the desktop again. So the doctrine of legitimate expectation is not listed here. That means that an investor claim under EU investment treaties cannot be based on a breach of the doctrine of legitimate expectation. So that's really important, because what makes the fair and equitable treatment standard such a broad investment protection standard is the inclusion of protection of legitimate expectations. So the idea is, when the government makes a promise and reneges on that promise, the government has to pay compensation to the foreign investor. That's the under case law, and traditionally that's the core element of the fair and equitable treatment standard. What the Europeans have done, they have excised that core element from the scope of the fair and equitable treatment standard, and thereby reduced the scope of application of that investment protection standard. It is still mentioned in the treaty, and I will show you in a sec. Let me just share again my desktop, the formulation that they used. They said a tribunal may still take into account the doctrine of legitimate expectation, but it can be inferred from the word may that it's not mandatory for the investment tribunal to do so. So they may take the doctrine into account when fleshing out, when interpreting the fair and equitable treatment standard. However, they are not under an obligation to consider the doctrine of legitimate expectation. So what the Europeans have done, they have not withdrawn from ISDS. They have institutionalized ISDS and have created proper investment courts, standing courts, that are to be merged into one multilateral investment court, currently being negotiated under the aegis of UNCITRAL in Vienna. So that's not in existence yet, and we don't know whether it will come into existence, but in its bilateral relationships, the European Union has established proper investment courts in its relationship to Vietnam, in its relationship to Singapore, and we will get an investment court in relation to Mexico. The agreement hasn't been signed yet, but the legal text is available on the website of the European Commission. But it has been finalized but not signed yet, and hasn't entered into force yet. So the Europeans, they guarantee remedies. Foreign investors can still sue the government, and they wanted that because the level of property rights protection in Canada, in Singapore, in Vietnam, in Mexico is lower as compared to the European standard. So they wanted to grant European investors the same level of property rights protection that they are used to, and made those rights actionable by providing investment courts. But at the same time, they watered down the most dangerous investment protection standard, which is the main reason for, in terms of liability risks for states. So 98% of all investment cases revolve around the fair and equitable treatment standard, because it's the broadest standard, and a well-advised investor will always base its claim in the first instance on the fair and equitable treatment standard. The second standard, the second most used investment protection standard is indirect expropriation. Direct expropriation is when the host state takes away the title, but that's too obvious. So when governments nowadays want to expropriate, they use indirect expropriation. That has the equivalent effect of a direct expropriation, but the foreign investor still has the title, the formal title in the investment, in the asset, but it has been devalued through actions of the government. So first of all, modern Western investment treaties recognize that indirect expropriation is covered just like direct expropriation, and they have taken a similar approach to that the European Union has taken with respect to fair and equitable treatment. They provide criteria in order to define indirect expropriation. So always when drafting an investment treaty, by defining the legal concept, you take away control from the judiciary, from the investment tribunals. When you when you don't define those investment protection standards, you leave it to the discretion of investment tribunals to flesh out those concepts. You give a lot of control to arbitrators. However, by specifying those investment protection standards, you tell the court what to do, what the work program is. They still have a lot of discretion to define those criteria, but at least you can provide guidance to arbitrators. And again, I will show you an example, this time from the Trans-Pacific area. So the most important trade and investment agreement for the region where I live in, the Asia-Pacific, is the Trans-Pacific Partnership Agreement, which is called nowadays the Comprehensive and Progressive Trans-Pacific Partnership Agreement, which has a chapter on investment law, and it has an annex on indirect expropriation. I will share my desktop again just to show you the formulation used. So you can see here that first of all, that indirect expropriation is accepted as a course of action, but it has to have an equivalent effect to direct expropriation. So that means the threshold is quite high. A substantial deprivation of rights is required. And then they list certain criteria, and they make clear that only because government action has an adverse economic effect for foreign assets, that's not sufficient to amount to a case of indirect expropriation. It has to be more than that. So in the past, it's called this the sole effects theory. So that doctrine has been rejected through that formulation, that only a negative adverse effect on foreign assets, that's not sufficient to establish indirect expropriation. So you can see that that modern treaty practice, by providing criteria, by defining those ambiguous legal concepts, states can give guidance to arbitrators and take back control. So that's one mechanism to adjust the level of substantive investment protection. So instead of withdrawing from the investment regime totally, the EU tackled the most egregious outliers of investment protection and tackled those. Before I conclude, I just wanted to mention one more case, which is really problematic, and some of you may have heard of that. It was a case brought by a Canadian mining company against Colombia under the Colombia-Canada Free Trade Agreement. It's that infamous Eco-Oro case. And that's problematic for a couple of reasons. And that might change how investment treaties are drafted in the future, in particular exception clauses. So Canadians used a slightly different approach in order to calibrate the level of investment protection. They incorporate exception clauses like we have in international trade agreements. So they said we guarantee that a classic level of investment protection, however, on human rights grounds, on environmental grounds, on public health grounds, we can deviate from our investment obligation because those other societal interests and values prevail over investors' interest in a particular situation. So that's the function of exception clauses. In international trade law, an exception clause excuses the government that the justified state conduct is lawful and the government is not liable internationally for that act of state. So, and everybody assumed, including myself and probably the people who drafted the Canada-Colombia Free Trade Agreement, that the same mechanism applies to exception clauses when making them applicable in an investment context. However, the investment tribunal decided the following, and that's why it caused such an outrage within the international economic law community. The investment tribunal argued as follows. So it found a violation of the Fair and Equitable Treatment Standard, but it accepted Colombia's argument that the rezoning of the mining zones. So that's what they did. They rezoned the mining zones for environmental reasons. And the Canadian mining company argued that that amounted to encroachment of their mining rights on their property rights, that rezoning of the mining zones. The tribunal found a violation of the Fair and Equitable Treatment Standard, but accepted the excuse, the justification that that was done for environmental reason. But then, and that's the important part, it still found that Colombia owes compensation to the Canadian mining company, even though the state conduct, the conduct by the Colombian government was justified for environmental grounds. So basically a reversal of what international lawyers are used to in the context of international trade law. How to fix that? Well, we might wait for new case law that counters that case law, and then the Oro case was just an outlier. But the safe approach for treaty drafters, in my view, would be to introduce clarifying language into exception clauses. So current exception clauses simply state the requirements of the exception clause, but they don't make the legal effects obvious. They thought they had made them obvious, but not in the eyes of the Oro Tribunal. So my suggestion would be to also clarify in the exception clause what the legal effects are, namely a state that invokes an exception clause successfully is not liable and does not have to pay compensation. So I'm just looking at the time. I will conclude here. There's a lot more to say, of course, but I think we tackled the most important aspect and issues that international investment law is grappling with at the moment. I hope you found my brief lecture useful. I'm happy to answer any question. Let me just say one final word. So when I left Venezuela, I really believe that you are the greatest country in the world. You have all the resources to have a happy life in your territory, a beautiful environment, beautiful weather, and I pray, and I follow the news closely on Venezuela. I pray that you as young lawyers will make a contribution for Venezuela to have a great future. Don't make the mistake of being your own worst obstacle. And if I can contribute by connecting to Venezuela, I'm happy to do so. Thank you for your time and for your attention. Muchas gracias.
Professor Riffel, thank you so much again for this beautiful presentation and for the big bunch of ideas that you put out throughout your lecture. Now I invite, let me turn into Spanish. Ahora vamos, muchas gracias, profesor Riffel. Queríamos, por supuesto, invitar a todos los aquí presentes a participar en la discusión y en los comentarios. Como les dije anteriormente, el profesor Riffel se maneja muy bien también en castellano y es posible formular las preguntas en castellano. Imagino que el profesor Riffel escogerá si las responde en castellano o prefiere responderlas en inglés. ¿Okay? Entonces, todos están invitados y bienvenidos a formular sus consideraciones respecto de esta presentación, de esta ponencia tan interesante, tan llena de ideas y de preocupaciones respecto de lo que ha supuesto el derecho de las inversiones en el mundo en general. Porque no es solamente un problema de un país o de una región aislada, sino es en todos aquellos países en donde hay un régimen de protección de las inversiones basado en el derecho internacional, se enfrentan a estos problemas en términos muy similares. Si no se anima ninguno
Sí,
ahora, ok, por favor, adelante. Rodrigo Quintero Bencomo, por favor, adelante.
sí, definitivamente me animo, and I hope I will be spared if I decide to ask this question in English. I really think it would be, I would really appreciate it if I had the opportunity to do so. So, Professor Riffel, thank you very much for your lecture. I think here in Venezuela we could use a lot of these lectures and dialogues, and I think it's a great opportunity to, of course, learn a lot more about these very important trends for us. I think Venezuela has the very unhappy fortune, if I could actually call it a fortune, of being the second most sued country in the world in terms of investment-related disputes and litigation. So I really appreciate the opportunity to hear from you, your thoughts and takes, which is also a compliment, by the way, to the organizers. I really appreciate that the Masters is actually organizing these kinds of events. So I have a couple of questions for you, if you have the time, of course. My first question for you is, at the very beginning of the session, you mentioned that incursions into national sovereignty is not necessarily a bad thing, which I totally agree. So my question, and of course, there are remarkable examples of successful experiences in that regard. So considering the progressive approach of the EU on this matter, and of course, the many times in which Latin American countries have been sued, and of course arbitration has been demanded and facing protracted litigation, my question for you is, what is the future trend in investment-related sovereignty concessions in terms of the extent of substantive protection to investors?
Muchas gracias, Rodrigo, por tu pregunta. Well, let me say two things. So, to be that those excursions into the domestic legal order is not uncommon. So we can see that in all areas of international law. As soon as a country accedes to an international treaty regime, it subjects itself to the obligations arising from that treaty regime. And for instance, when we negotiate an international climate agreement, of course, we want countries to fulfill their climate reductions commitment. So that would be another incursion into the domestic legal order. So yes, it's not necessarily a bad thing, and sometimes we want to exactly bring about domestic law changes through the means of international law. As to the second part of your questions, the new trends, I think there are two. So you can see that most
o podrían poner en jaque a algunos estados pequeños, ¿no? O sea, ser una carga realmente para el bolsillo de los estados. Entonces, por eso es que muchas de estas cosas yo creo que fueron sorpresas. Sorpresas porque no se anticiparon, y simplemente lo que hemos tratado de ir haciendo es ir curando los problemas que nos hemos ido encontrando con la experiencia práctica. Y todo se ha ido creando y cambiando sobre la marcha, ¿no? Entonces, eso genera muchos problemas, y ahora es que creo que podríamos pensar que estamos, no sé si como en una tercera etapa del Law of Investment Protection. Y creo entonces que vienen todas estas reflexiones de definir algunas cosas que quedaron muy vagas en los tratados anteriores, que la jurisprudencia de los tribunales arbitrales nunca aclaró, y que para mucha gente siguen siendo términos demasiado flexibles, ¿sabes? Todo se acomoda, bueno, el fair and equitable treatment, eso es según la necesidad del reclamante, ¿no?
Creo que es necesario recalibrar el nivel de protección, es muy importante. Bueno, tengo que responder la pregunta de Rodrigo, pero aún no apareció.
No sé si... Una pregunta, Claudia, ¿estamos grabando ya esta parte también?
Sí, ya recompusimos.
Entonces, si quieres la contestas y la graba, va a quedar recorded, ¿no?
Bueno, voy a hacer eso entonces. Hi, Rodrigo, we are back. I still owe you my answer for the second part of your question. So I think the latest development, international investment arbitrations are and will be in the energy sector. So as we move away from a fossil-driven economy towards a green energy economy, lots of investment disputes are going to arise in those energy sectors. So we had those cases recently against Spain and Italy. Both countries rolled out big subsidization programs in order to attract foreign energy companies to invest in the solar industries. And then those subsidies became a burden for the national taxpayer, the national purse, and they became unaffordable for the government. So they had to reduce the amount of subsidies. Of course, the foreign energy companies argued that you, Italy, you, Spanish government, you made a promise, and now you're reneging on that promise. We are getting less subsidies than you had promised, and we invested into your country exactly then your commercial interest is in low investment protection. That you want to grant as little investment protection as possible, but still attract the foreign capital. So the first step is to have a clear idea about your own economy, where do you stand, and be realistic about it. And then the second step, and I think Australia and Brazil did that very well, they reduced investment protection and checked whether they still attract foreign capital, whether they're still attractive. And they were. So Australia got rid of ICS in certain investment relations, and people still kept investing into Australia. And the same happened with Venezuela. So not all country is in that position to do so. Most countries, such as Venezuela, have investment agreements, not because they want to, but because it's linked to MIGA, the Multilateral Investment Guarantee Agency. In order to get those investment guarantees, it comes with conditions, and one of those conditions is to sign investment agreements. So it's pressure from the World Bank. It's one of the World Bank conditions. So many developing countries don't have investment agreements because it's useful for their economy or it serves their commercial interest, but it was imposed by the World Bank. It's part of the World Bank conditionality. So a country like Venezuela or New Zealand cannot change, doesn't have the power to change the international investment regime. I think the best shot that small countries like Venezuela, like New Zealand, or a middle-sized country like Venezuela has is a rules-based system, because otherwise countries like New Zealand or Venezuela are at the whim of the superpowers. So it's always better for smaller, middle-sized countries to have a rules-based system than have the rule of the jungle apply to them. So even though the rules-based system is imperfect, it's better than the converse, having no rules. So my preference would be to have a multilateral investment court. So I support the project of the European Union to establish one. And I think it will ensure more consistency in decision making as compared to the current ad hoc system. I don't think that it's at odds with the international rule of law, as some people argue, but I think that a standing body will be better and will serve the international community better. But it might be my European background. So Europeans are very used to international courts. We have the European Court of Justice, we have the European Court on Human Rights. So Europeans don't see an international court as an incursion into national sovereignty, to come back to the topic of my talk, to the same extent as American, for instance, would see the jurisdiction of an international court. So thank you.
Thank you, sir. Thank you for your
My administrator just knocked at my door and said, I have 2 people waiting for my signature. I hope it's okay that I say goodbye. I just wanted to say that that's an excellent program, so private international law. And I always found, even though I'm a trade and investment lawyer, I always enjoyed the interaction with private international lawyer. In my books, those are the coolest lawyer, and the reason is you can think laterally. In my experience, people who specialize in that area of law that you are specializing are the most intelligent lawyers, because you're not stuck in the way. We all are siloed and specialized in a certain extent, but I always found it is very easy for people specialized in private, international, and comparative law to make links to other legal orders and to learn fast on new legal problems. So it's a really useful skill to have. So let's stay in touch, and I look forward to the future collaboration. Buena suerte con tu futuro estudiantes y bueno, suerte.
Bueno,
adiós, nos vemos, Eugenio.
Todo lo mejor, muchísimas gracias nuevamente, y cuando lleguemos mañana el viernes volvemos a decirte muchísimas gracias.
Let's not wait for another 10 years. Bye bye. Adiós.
Goodbye. Gracias a todos. Muchas gracias, buenas tardes, y bueno, despedimos nuestra sesión número 22 de nuestra masterclass, agradeciéndole muchísimo a todos ustedes por su participación, por sus comentarios, sus preguntas, y también, por supuesto, nuevamente al profesor Christian Riffel, que como ven, no solamente es profesor allá en Nueva Zelanda, sino que tiene cargo honorífico de cónsul de la República Federal de Alemania allá en la isla del sur, en Nueva Zelanda, donde ya es 5 de agosto. En lo que queda del día 4 para todos nosotros, lo mejor, vamos a disfrutarlo y nos vemos en la próxima ocasión. Buenas tardes a todos.